We are recording.
All right, thank you very much. Good afternoon. The appellate court is back in session. For the record, we are conducting this hearing via Teams and are live streaming this hearing on YouTube. For some reason, I'm hearing some. Perhaps if everyone could keep their microphones muted for now. All right. We are conducting this hearing virtually via Teams and are live streaming this hearing on YouTube. Counsel advised that to the extent that there is statutorily protected parties and or information here, that you must take care not to reveal said protected information. I would ask everyone participating in the hearing to identify themselves, starting with the judges, then counsel for the appellant, and finally counsel for the appellee. I am Judge Elgo.
Good afternoon, I'm Judge Suarez.
Good afternoon, Judge DiPentima.
Good afternoon, Michael Devine, counsel for the appellant.
Good afternoon, Jennifer Bar-David, counsel for the appellee.
Thank you very much. So for the record, I note that I can hear and see everyone. Please let us know if in the course of your argument you're experiencing any difficulties hearing or seeing the participants. If you should lose your audio or video capability, please log out and retry the Teams link that you were sent for this hearing. We will then take a pause in the recordings. All participants must keep their video on and remain in view out of respect for the process and the participants. And all participants are also asked to keep your microphones off and muted when you are not speaking. The judges will raise their hands if they have a question to avoid talking over whoever is speaking, but will interrupt you if for some reason you do not see them. Please keep in mind that while this is a virtual hearing, all participants are expected to conduct themselves with the same formality and respect for the process as you would in our courtroom. Each side will be permitted 20 minutes of argument. The appellant may reserve a portion of that time for rebuttal and should advise me before you begin how much, if any, time is requested for rebuttal. Judge Suarez has agreed to keep time and will give you a 5-minute, 2-minute warning and when your time is up. So we will now hear from the appellant in the matter of Bologna versus Bologna. All right, the appellant proceed.
Thank you, Your Honor, and good afternoon, everyone. I'd like to reserve 5 minutes for rebuttal, if possible. Thank you.
You've got it.
I think the trial court erred in two critical ways in denying my plaintiff's motion. The first is by narrowly looking at the decree and focusing on one sentence in the decree that the plaintiff should continue to make mortgage payments until the marital home is sold. I think that led to the conclusion that anything that the plaintiff was asking for was a modification. And the second way in which, and I'll get into details after I lay them both out, the second way in which the court critically erred was the court failed to recognize the non-compliance or the default of both of the parties. The court essentially said, the plaintiff was in compliance with the agreement. The plaintiff continued to make payments. Therefore, there's no default here, and there's no ask to be cured. There was a default. The default was the failure to sell the house or list the house by a date certain, and I'll go into the analysis there. But yes, sorry.
Counsel, may I interrupt? When you say default, how do you count for the introductory phrase in the you know where I'm going here with statements that says unless otherwise agreed by the parties, or something to that effect? Can you clarify how a default can be, or a default can be understood under those circumstances?
Sure, Your Honor. I argue that unless otherwise agreed by the parties is significant material way of agreeing. It's not just non-compliance by either or of the parties or the ignoring of a requirement, but rather, the decree itself says in an article that any amendments or changes need to be done in writing. Clearly, prior to the June 2012 date, the plaintiff in her exhibit said, look, I'm willing to go past this date, but I'm only willing to go past this date if, the principal payments are applied by the person making those payments. That went ignored by the defendant. And lastly, if you look at all the actions post June 2012, the plaintiff on a bunch of occasions, and arguably the defendant did the same, reached out to one another to try to get agreement on when to sell the house or to sell the house to one another. They didn't otherwise agree, is what I'm saying. There was no meeting of the minds. There was nothing that rises to the level of modifying a divorce decree because they ignored the date. It's really a default, not an agreement. They didn't memorialize this in any way, and they battled over it for the next 7-8 years. And that's why I don't believe it's an agreement, but it's clearly a default.
And what's your authority, Attorney Devine, for saying that leads to a reversal in this case?
So I think the fact that there was no agreement means that there was a date certain by which they were supposed to sell the house. And if you were to agree that there was no agreement, and to agree that there was an agreement would mean that you'd have to take the defendant's approach that even though the plaintiff knew she was at risk of making payments on behalf of both the plaintiff and the defendant going forward, she ignored that risk and just continued to make those payments. So I really truly believe there's no agreement. Having said that, now there's no agreement. There's a default, a non-compliance. It's by both parties, but I think there's lots of cases, and Schneider's probably the most applicable one, which says if there's a default by the party, the court has the jurisdiction to fashion a remedy that ensures timely compliance, and that goes back to the effectuation of the judgment. So what could the court have done? The passage of time had occurred. There was no way of fixing that, and the court can go back and look at what should have happened had they complied with the court order at the time. No one should be rewarded or benefit or to the detriment of another party because of a non-compliance, and that's what's happening here. Is there was yes,
but in Schneider it was one party defaulting, right? It wasn't both of them. And clearly here you have two people who are, for whatever reason, not complying with the explicit provisions of the agreement.
Agreed.
Maybe a tacit agreement not to comply, whatever it is. So I'm just, is there any other authority that you think would?
Well, I think I don't think the fact that both parties or one party's in default matters. The fact that a default occurred is what's important, and the ramifications because of the default. If they had not defaulted, this is a unique situation that what we have to look at. We've jumped to the second argument, but the first argument is that the parties had a joint liability that they agreed upon, that what did not change because one party, for convenience sake, had to make payments on that. That liability was $700,000. It was static in nature through the date upon which they were supposed to sell the house. The fact that after that date, the liability was decreasing, it is only a matter of convenience because someone had to pay the mortgage payments, but it doesn't affect that a joint debt was assigned by to both of the parties. It's not like suddenly, because now it's July of 2012, one party has assumed all of the liability and the other party has assumed none of it. And that's the effect of what has happened here. And my argument is you don't need to get to a default in order for the court to have had jurisdiction. This was clearly effectuating the intent of the original decree and the integrity there, because there was a clear debt that was assigned to both parties. And then that debt was, that debt hasn't changed just because someone paid it down.
Counsel, one of the aspects of your argument that I don't really understand is that because there's an assumption that there is a split of the proceeds and a split of whatever deficit there was. Certainly that would have been clear in June of 2012, whatever the status is of the value of the home. But given that the agreement contemplated that the plaintiff would be leaving the home, selling the home, and then leaving the home, right?
Yes.
And presumably, by whatever resources she had, she would be paying at least rent or, some value. She'd be paying something in order to live in another home, right?
Yes.
And so why is it then that the value that rather than renting another residence or paying for the rent of another residence, she decides to stay here and instead take those monies for her living, her cost of living, for her residence, and applies it towards the principal, right? So she's getting the value of living in her home for the period of 7 years, right? So why would the defendant then be essentially responsible for that post 2012?
So I would contend, had they sold the home in 2012, she would have had a sum of money, perhaps, that she could have then bought a new home and paid down that mortgage by the same amount. And first, or paid rent or what have you. And there was no evidence of, benefit to one or the other parties in the record, I would like to add. But the fact that she then applied that, another way to look at that is she applied the debt, not pro rata 50-50, but she applied the principal payments that she made to her half of the $700,000, right? You could look at it that way as well, and that the defendant, who agreed at the time, was liable for a $700,000 mortgage, continues to be liable for half of that mortgage still, and that she made principal payments towards her half. That would be a reasonable approach. It's a windfall to the defendant to, who didn't do anything during the 7-year period, other than send a nebulous email here or there until 2019. He took no steps or no actions to secure the value of the home, to sell, to make sure that his rights were enforced. He sat back and just benefited from my clients paying the mortgage. Again, I believe that the way that the agreement's constructed is that the mortgage was a joint liability, and that people anticipated the agreement would end when they sold the home in 2012, and therefore the debt, they never anticipated the debt would still remain outstanding some 7-8 years later.
Counsel, I have a question. If I can turn to the agreement itself, section 5.4,
Yes.
which is page A40 of your appendix. When it talks about the sale of the property, it uses language that's such as the agreed upon fair market value of the home. That assumes at the time you sell it, because obviously the values of home change. And later on in subsection C, it talks about the remaining proceeds. Those are things that obviously will go up and down during the course of 10 years.
Yes, Your Honor. And I go to two facts. One is the parties, when they signed this agreement, they had no expectation that they were going past a date certain. That date certain was when that mortgage was going to flip from interest only to principal and interest. So when you look at these things, it's under that, that was drafted with that expectation. That said, the lead into A and C is, unless otherwise agreed by the parties, they shall list the home for sale according to the following. So they were supposed to have listed the house for sale by the date in which those net proceeds were going to be $700,000 less, because the mortgage was going to be $700,000.
But the problem is that they both, nevertheless, agreed to go beyond those dates.
Agreed, but why should one party be penalized and the other one receive a windfall for doing nothing but the passage of time. He's not harmed in any way, Your Honor, because we're selling the house today as opposed to in 2012. But she's very well harmed because she's made all these principal payments. And it's solely because someone, there's an agreement earlier on that someone out of convenience has to pay the mortgage until the house is sold. I mean, they schedule how they share kids at Christmas and all sorts of things. Someone had to be that, but it wasn't an allocation of value of a liability that says, okay, after June 2012, now the liability all shifts from one party to the other.
Assuming the price of the house, the value of the house remained the same, and the debt remained the same over the past 10 years, you're right. But the reality of life, it didn't. The value of the house went up and the debt went down. So by now going towards a June 12 date, it seems to me that you're changing the terms of the agreement.
I would disagree because I think we're focusing on the wrong thing. We're focusing, the attention here is focused on the net proceeds, right? This is akin to what should the broker fee be or what should the taxes be? This was a debt that was assigned to both parties, right? There's no other provision in here. Why would they list $700,000 to identify the debt? They could have listed the account number. They specifically agreed on a number. And that's the number that's being applied, and the fact that it's being reduced now is irrelevant. And you're right. The prices, the house could go up in value or down in value, but that's either to the rise or fall of both of the parties, not to just the one.
Attorney Devine,
Yes,
you've been saying how this is all about a debt, and the provisions in the agreement that I've been directed to are all about the asset of the house. And I agree that the language says that in, I guess it's 5.3D, that the plaintiff is going to pay the expenses related to the house. And that's what I guess the parties relied on. Both parties relied on that until the closing of the sale, right?
Yes, Your Honor, that's correct.
Closing the house, excuse me.
Yes, no, I understood, yes. But 5.1 says, here's the debt in joint name, and here's the amount of that joint debt. And the parties testified and knew that through 2012, or June of 2012, that debt was going to be static.
Unless they otherwise agree.
And it's very difficult for me to find where, Article 16 of the agreement says that any agreement needs to be in writing, signed by the parties.
All right, counsel, your time is up. You can certainly take more time and then just have reduced rebuttal time after.
I'd like to take 3 more minutes, please. Thank you.
Okay. Do you have 3 or 4 minutes?
Okay.
You may have as much as 4 minutes, but.
Thank you, Your Honor. I'll take the 4 then.
Okay. All right. Attorney Bar-David.
Thank you, Your Honor.
I'm sorry.
I think he wanted more time from his, right? You
Yes,
wanted to
yes,
take
Your Honor.
more rebuttal time.
Yes.
Oh, okay. Go ahead. I apologize. All right. Judge Suarez, just how much time is left? I'm sorry.
Yeah, he's got 4.5 minutes.
Okay, go ahead. All right, continue, Attorney Devine.
My apologies, Your Honor. Your Honor, yeah, it's clear in Article 16 that to have an agreement has to be in writing and signed by the parties. They didn't do that, right? They just simply ignored. The fact that both ignored, I understand is a concern, but the default, then we should go back to the status quo regardless. And if you look at the record, the plaintiff tried on several occasions, 6 occasions, I think, including sending an appraisal over to the defendant, which he admitted he ignored because it wasn't a value that he thought the house would be at. So he just sat back and waited and just collected the benefit or the windfall, which I think Snyder was trying to capture and say, that's not appropriate.
Well, I thought the record reflects that he, on at least 2 occasions, wanted out of the house.
He said that in an email, Your Honor, but what he didn't do was take any steps, right? He didn't actively get an appraisal until his first one, which was in 2019, right? March of 2019. So he sat back for 7 years almost and did nothing while the balance on the account was being drawn down.
Well, I thought her alternative to him was sign the house to me, but remain on the mortgage.
That was one of her proposals, but she emailed in 2011. She emailed in 2012. They went to mediation. 2014, she had a CMA. 2017, she sent another email. 2018, she sent, they had a discussion in mediation again. I mean, that was only one of her proposals, but he didn't even make an appraisal or say that he wanted, to get the benefit of this payments down by her until 2019, when even before 2012, she said, and I mean, if you're going to say there's an agreement, I think you need to look at all the terms, and part of that would be the terms that she wrote in 2011, as self-serving as they may be, that, look, I'll stay in the house, provided that I get the benefit of the mortgage payment. So to think that she then just ignored that, and stayed in the house willy-nilly when he just ignored that email, it doesn't make sense to me. Not that it has to, but.
Is there, Judge Suarez, is there 2 minutes left for rebuttal, or he has two minutes
left for rebuttal?
Thank you, Your Honor.
Okay, all right. Counsel?
Thank you, Your Honor. I'm going to make my argument brief because I believe it's a very straightforward issue in this case. The motion to clarify in this case was actually a motion to modify. The plaintiff is asking the court to alter the terms of the separation agreement to give her the sole benefit of increased equity due to mortgage payments she made, which the court had no authority to do. The motion for clarification is appropriate where the terms are ambiguous in a decision, which is not the case here. And the language of Article 5.4C is very clear. In fact, it says, as a property settlement, it says that in the agreement, the remaining proceeds will be divided 50-50. So by now asking the court to give her the benefit of her pay down on the mortgage, she's asking for a modification of a property settlement, which the court simply cannot do. And the trial court recognized that in its decision. It says in her motion to clarify, the plaintiff asked the court to alter the terms of the separation agreement. The court has no authority to do so. The Schneider case has been discussed at length here, but in that case, the defendant was required to pay all the household costs, including the mortgage, and failed to do so. The plaintiff did that and then was asking to be reimbursed. So in that case, the court was effectuating the judgment. In this case, to give the plaintiff a credit for the mortgage payments she was obligated to make would alter the percentage distribution of the proceeds of the sale. And the defendant would be reimbursing the plaintiff for payments she was obligated to make. Again, if the parties had wanted to alter the terms of this agreement, they could have opened and modified the judgment, and that was never done. And also, the home could have been listed for sale. There was a lot of discussion about this in our evidentiary hearing, and in that there was correspondence between the parties. The plaintiff's offer to the defendant was that he could sign over the house to her for nothing. So he did not agree to that. This is a situation of the plaintiff's own creation, and that she wants the benefit of living in the house without the consequences of which she is aware. She was a party to this agreement. As the trial court points out, the plaintiff made the payments at her own peril. And again, she will receive a benefit when the home is sold for any increase in value. although it's not part of this appeal, as part of the court's decision, the plaintiff insisted on reimbursement for half of the repairs that were made to the marital residence during the time when she lived there, even past the 2012 date. So she wants to pick and choose which portions of the agreement she wants to have enforced.
Counsel?
Yes.
I'm glad you brought that up, because I was looking at the opinion, the court's opinion, and it looked as though, in fact, the court did order your client to pay 50% of the repairs. Is that right?
That is correct, Your Honor.
Okay.
That is correct.
So she ruled, the court ruled in favor of the plaintiff in part.
That's correct. That was a motion for contempt regarding the payment of the repairs to the marital residence.
Okay. Is there anything beyond that to your knowledge, that the plaintiff is seeking?
She was seeking, as part of it, she was
Repairs.
repairs and improvements. So the court had to make a distinction between improvements that the plaintiff had done to the house, for which my client was not responsible, and then necessary repairs, for which he was 50% responsible.
Okay, thank you.
You're welcome. The other point I wanted to point out in section 5.4 is that not only would the proceeds, if there were any at the time the house be sold, be divided 50-50, but if there were a deficit, then that would have been divided 50-50. So again, the plaintiff didn't ask that be altered, in which case my client would be responsible for half of the deficit. I'll rest on the remainder of my brief unless there are any further questions from the court.
I have a question. This mortgage on this property is the original mortgage from when they were divorced, correct?
That is correct.
By its own terms, it changed from a interest only to interest and principal, correct?
That's correct. That's correct.
And the plaintiff was aware of that?
That's correct. There is testimony. There was testimony to that effect during the hearing, that was contemplated and discussed during the mediation. And I just would like to point out that the plaintiff has made a fact of it that the amount of the mortgage is listed. However, if you look at 5.1, it says the current outstanding balance. It was just merely listing what the current balances were of the mortgages, not that was the only amount to which they would be responsible.
Okay, I don't believe there are any further questions. Thank you, counsel. Attorney Devine.
Thank you.
Yes, thank you. Just on the maintenance payments, just real quick, if those maintenance payments didn't occur, the defendant, the value of the house would go down in value, and therefore that would have been played out either way for both the defendant and the plaintiff. So the fact that they shared in that just maintained the value of the asset that they had. I would like to say that, I think when you look at the trial courts made a determination of the practical effect of its order, because it did say it was unfortunate for the plaintiff for her complying with an original court order by making additional payments at her own peril. So additional meaning above and beyond, as it was talked about in Schneider, from what was contemplated. So the trial court, when you look at the difference between a modification and an effectuation, you look at the effect, the practical effect that the court order would have. I don't believe these parties agreed. I believe that therefore we were in some kind of non-compliance, but even without that, there was just asking for something, a clarification on an amount, as it was not an additional alteration, an amendment. It wasn't adding a new element, or canceling one. The new element was shifting liabilities from the joint responsibility of the parties to just the plaintiff. That was the new element. And with that, I would rest unless there are any other questions.
All right, I don't believe there are any other questions. I want to thank you very, very much, both of you, for participating in this virtual hearing. We look forward to seeing you in our regular courtroom sometime in the future. We'll take this matter under advisement and then recess until 4 o'clock. Thank you very much.
Thank you.